All right, good afternoon, folks. This is Curt
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for November 6th of 2023. Brad, go ahead.
Well, let's start in South Carolina. I have more questions than answers. We don't know a lot about this, right? So I'm going to throw out my normal, I'm curious, but here's what we believe we know. A South Carolina fire chief who resigned about 2 weeks ago is now facing allegations that he misappropriated $42,000 worth of overtime since July of 22.
Not so much misappropriate. That's he put in for the overtime.
Well, and that's kind of my question, right? Because is it that he was entitled to overtime and he put into it believing he wasn't exempt from FLSA, right? Which is a fair question. Was he putting into it secretly? I mean, unless he was cutting payroll, it kind of bewilders me how people didn't catch this and say, hey, you're not entitled to it, right? And crimes require intent to defraud. So, right. I those are the questions I have. It doesn't seem like I'm not trying to come to his aid or attack him. I'm just saying that's pretty blatant when someone's doing it. It doesn't seem like they're trying to get away with anything unless they're the one who cut payroll.
There's two things that stood out to me on this one. Number one, whether or not he was in fact trying to take advantage of something he wasn't entitled to. Was he trying to put in? One of the other things, and I know particularly in small towns, sometimes there are ways around compensation that work themselves into the process here, where somebody says, well, I know we'd like to pay you $75,000 a year, but I can't pay you 75, but we'll give you overtime. Right. And so whether it was one of those deals, and now possibly the person who said to do it that way is no longer there, and now somebody else who's looking to get rid of somebody says that's what's going to happen. So do we really have a crime here? Do we have maybe something that could be criminal too? Because now, you run your business, I run my business. If I want to pay somebody overtime when I don't legally have to pay them, we can do that, right? But when you're dealing with the public's money now, there's a question about whether or not it was a workaround or whether or not it was a conspiracy to defraud the taxpayers. So I think the state police are going to have their hands full in looking at all the different aspects of this. So
I hope he has a good attorney, honestly.
I do too. I do too. And I hope that, it's not a witch hunt to get this guy either, that they are actually going to look at all of the, and I'm sure they will, all the different aspects of it. But we've got a class, Bill Macarone's teaching a class this week on whether or not officers are entitled to overtime. And, there's been disputes ever since the FLSA applied to the public sector in 1985. And that's in big picture, that's relatively new, a new area for us. But there's been a lot of disputes about whether any officers are entitled to overtime. And it's come down pretty clearly that there are many officers, if not most officers, are entitled to. But one of the very clear exemptions is the executive, the fire chief. But there are some factual questions in given cases whether or not a fire chief could qualify as an overtime eligible employee. So Bill's going to talk about that Wednesday, along with whether or not a company officer, battalion chief, deputy chief, right on up qualify as well. There's a lot involved here. So I think, the state police, I hope they have, I hope they have their FLSA hat on when they go into this as well, because that's going to be part of what they've got to look at.
And this is not the normal, let's call it theft of time or overtime case. Normally it's, I'm billing here, but I'm over at another job. Right. And that's got some scrupulousness to it. But this is so in your face. And look, your and my natural inclination is to protect the fire department. So maybe there's a little bias here, but nonetheless, this is so in your face and been going on for so long. I really question whether somebody had the intent, right? The mens rea, we call it in criminal law, right? The intent to defraud anybody. One hallmark
of fraud is an effort to conceal what you're doing. Right. And when
Right.
the flip side of that is when you're just doing something without intending to conceal it, it suggests that you thought you were doing something legal. And it looks to me like if he's putting in for this and it's getting approved through whatever process they have, that he's not trying to hide anything.
If I was on the jury, I wouldn't think he was trying to hide anything. It's getting submitted. I'm presuming. I'm presuming he's not doing his own payroll, right? If he is, okay, that's a whole different issue.
But we also have our bosses, and unless you're the mayor, and then even the mayor, we have the balance
Clerk,
of power.
finance,
So you have the
payroll department.
legislature, the mayor, and the legislature
Right.
are supposed to. So somebody's got to be looking at this, and then if not, I mean, if nobody's looking at it and he's aware that nobody's looking at it,
Then
and
maybe.
he's exploiting it, But a lot of interesting questions come out of that particular case. Yeah.
Exactly. Okay, let's go into New York, where we have, this is just preliminary stuff, and I'm not sure. I mean, there's interesting stuff here, but I think for viewers, what we're going to talk about is, hey, what does this mean? So we have they're called a lot of things: protective orders, anti-spoliation orders, right? Evidence preservation. And I want to talk about that with people because these are common. But normally the first act when and I'll give the facts in a moment, but normally the first act when a lawyer takes in a lawsuit and has questions and wants to make sure evidence doesn't get destroyed, videos, reports, right? All of this, they send a you can, again, call it whatever you want, but preservation, and a lot of times these are electronic preservation notices, whatever they are, they say, don't destroy anything. If it affects this, if it even possibly affects it, don't destroy it.
So evidence preservation request is
preservation request, right? And there's a civil practice law and rule, civil procedure in New York that we use, and we just...
Oh, Brad, I just lost your volume. Just lost your sound. Brad's at home today, so nope. I can see you.
You can see.
It just came on.
Hold on.
Yep, we got you.
Okay, so wait. Okay, so I'll try to hold. So what we have here is we have a woman whose a woman's fiance and 2 children were severely injured in a gas explosion in Keemesha Lake in September of 23. And she filed a petition to order her landlord, the propane supplier, the local fire department, interestingly, to preserve evidence. Now, fire departments would never get rid of evidence, right? It's a criminal arson issue. Whatever.
Oh, yeah, we would never. Yeah.
We would never, no. But nonetheless, so what she's claiming here is obviously there was something that happened. There was a gas malfunction that caused the explosion because the home was just serviced. And she wants preserved, her lawyer wants preserved some really interesting things, right? Like soil samples, which I think is really interesting, but good for them. They're going to spend some money on experts, but good for them. So, they want soil samples. They want things about tanks and any pictures, audio. This is basic stuff. But when you receive it, people act one of 2 ways on these. And I want to be clear, your way you react isn't to try to start finding stuff and shredding it. Right. So this comes with criminal consequences if you destroy these preservation notices. So don't, is my only point for this, I guess.
Yeah, this interests me, and I thought it'd be interesting to everybody to understand that this goes on. And a lot of times we don't realize, especially if you're on an engine, a ladder, or an EMS unit, you're totally unaware that these things are going on after we go to the fire. We put it out, we leave the scene, we go back, we get ready for the next one. But this is the kind of stuff that happens. And when I was at the NFPA, there was a fatal fire in Warwick, Rhode Island. And one of the attorneys, and this was, I was doing Fire Law blog back then. There was no vlog or anything of that nature, but it interested me. So I reached out to the attorney, and I don't know if we did a podcast or not, but I thought it was such an interesting thing because it was a fatal fire. And he immediately, like the day after the fire, put in a similar petition under Rhode Island law. We can do basically the same thing. And it went to the fire department, the state fire marshal, Several of the other parties, there's a landlord, there was a property owner landlord who's different, person who maintained the property, and then the tenants. And the question that the attorney had was, what caused the fatal fire? Because we're going to go after, if it was a light switch, if it was a stove, it was a dryer, we're going to go after whoever caused it. So I had an interesting conversation with him, and he said, this isn't new. And I said, really? I've been practicing. At that time, I've been practicing for, 25, 30 years, and I had never heard of it. And he said, no. He says, we did this for the Station nightclub fire as well. That's 100 people died in that fire. And the idea was that when you have a potential stake, and it could be that you want to sue somebody, it could also be that you want to defend yourself. And this is where the fire department could feel a need to do this if they feel that someone is going to damage the evidence. That basically what happens now is the court takes responsibility for the scene. And then if there's going to be any testing, and this is particularly destructive testing, where you're going to test certain components of the electrical system, whatever, that it's done in a way that it preserves the evidence, and that whoever does the testing is not going to be accused of spoliation. Because if you do destructive testing of something and someone who had an interest in it was not involved in that testing, it could be spoliation. So it's an interesting thing. Again, it's not the type of thing where if you're on an engine, a ladder, an EMS unit, you really kind of give a crap about it. But it is an interesting thing, and it is relatively rare. But I did a class for this. It was an association of defense attorneys who work for insurance companies, and I lectured at one of their conferences. And just preparing for that, in the insurance world, this is a fairly common practice. And I'm sure Chip, our friend Chip, would probably be up on this, and that it could almost be malpractice for somebody like Chip not to do this in the right situation. So interesting. I thought it was interesting. So
lawyers, a good lawyer will always place a hold on evidence. I have a case now. I wanted to explain this. I have a case now going to trial in January, and we have a portion of video that was recorded at a firehouse camera. And I request the whole video, and the whole video doesn't appear to exist anymore. But one portion of it, right, which the defense views to favor them, seems to exist. So so here's what I've done. I've requested, because I want people to see how this works. I've now subpoenaed under court order the logs of the destruction, the deletion, the accessing, right? I want to see who copied it, who deleted it. Did they just copy it and then allow the rest to be deleted because there should have been preservation? Yeah. And you're going to get caught. If you play these games, I'm just saying you're going to get caught. Here, I'm going to see those logs, and somebody is going to get caught if they destroyed them. And that's why those logs exist. Your
knowledge of the internet and the way the computers work and the typical types of logs and what information is available in terms of deleting and all that, most attorneys are not going to have that kind of expertise that you have. So that they're in trouble. That's my point. They're in trouble. They've got the wrong guy at the other end of this lawsuit. So
and by the way, everyone should know there are internet service logs and logs for almost everything. If you're screwing with QuickBooks has a full audit trail, and a lot of software, financial software, has an audit trail, and your internet, anything that connects to a server has an audit trail. And they don't go away, and it's all public record. A lot of courts have held that the audit trails, right, deletions, accessing recordings, turning on, turning off cameras, all in an audit trail. Don't mess with these. You're going to get caught, is my warning to everybody. Okay, the next one I find interesting, and I'm going to make it a little more confusing than it needs to be, because I find this so interesting for many reasons. Let me start before I go through the facts, because I feel like we're back to 1990, why this happened, and you'll see why I say it. But the statute issue, we're in New Jersey. Now, in New Jersey, there is a statute, New Jersey Statute 59:9-2, which is the Tort Claims Act. A tort is a negligence lawsuit, and it limits personal injury, pain, and suffering claims against public entities. And it says you can't sue a public entity for pain and suffering unless you have a certain type of injury, like it could be a fracture or things like that. But pain and suffering here, what they needed in this case is permanent loss of a body function or permanent disfigurement or permanent dismemberment, where the medical treatment expenses are in excess of very low, $3,600. Yeah. Now, let me start by saying, well, if everyone's saying this is just New Jersey, we're not going to pay attention unless you're in New Jersey. But be warned, because this is interesting. This is why I find this very interesting. In New York and many other states, this language is exactly like our no-fault statutes, meaning if there's a car accident, this is just like the no-fault statute, where you have to prove that you had a serious injury in order to even commence further. Right now, what I find interesting about that is, notice what I just said. You have to prove you or establish you have a permanent injury before you can even move further with a motor vehicle issue. You got rear-ended by somebody. Here, so what happened is this. Let me give you the facts. I'll tell you the jury stuff or the judge decision. So here, and this is why I think it sounds like a 1990s pump. Remember in the old pumps, right? And us and probably a lot of other people watching remember this. You would get out, brake, neutral, pump, drive, right? And you'd hit a brake, put it neutral, pump, drive. Hopefully you didn't forget the neutral part and take it out of drive, right? But when you put it into drive, it was moving the transmission from drive gear to pump gear. And then you'd get out at the panel when we had dials, not the buttony things, and you would rev up the engine. But if you left it in drive and didn't put the transmission, the PTO, right, back to pump gear, your engine takes off on you unless you chocked it, right? Which a lot of times
even if you chock it. Sometimes even if you chock it.
Even if you chock it, go right over it. So I have a client who this happened to, unfortunately, a number of years ago, this exact thing. They turned the dial, revved it up, but forgot to put the PTO back into pump gear, and it took off and hit a house. So here, that's exactly what happened. I don't know why it took off, but it clearly wasn't in pump gear. It was still in drive, and it took off and runs into a business, injuring people, right?
Directly across the street from a firehouse. So they must have been doing this on the ramp. They must have been, at the station, and it goes directly across the street and
right into knock somebody off a desk, whatever. So what happens here is they sue, obviously, but the judge at the trial court kicks it out because they said there's no permanent loss of a bodily function, which is exactly the words in many, like New York's many no-fault statutes. And the appeal court reversed and said it's a jury question whether or not whether the loss of balance that this person suffered was substantial and permanent. What I find interesting, and nobody else is going to, is in no fault world, in car accident cases, this doesn't go to the jury. You can't even proceed to day 2 if you don't establish through affidavits and medical reports that you have a serious injury, one of these things. I'm surprised that the judge says, we're going to let you go all the way through this, right? The appeals court said, we're going to let you go all the way to jury trial, but at the jury trial could rule that you have no jurisdiction. That's why I'm surprised, right? That a jury is going to rule on a jurisdiction question. I think the court got it wrong. I think the court is wrong that it's a jury question, and I think it has to be solved by the judge as a trier of fact, right, in the first instance, just like no fault cases. The other interesting thing, which I didn't look up New Jersey's law, now she gets hit with a fire truck, right, injured with a fire truck. Mm-hmm. There also may be in here no fault requirements, right? So I'm wondering, if you get hit with a truck, it's a car accident, right? Even if nobody was driving it, still arises out of the use or operation of a motor vehicle. Now I'm quoting New York's language, use or operation, but I'm betting that's most statutes are all generally similar, except maybe in Louisiana or Texas or something. But nonetheless, I would have also raised the defense, and if you're listening, I would have raised the defense of the fire department arose out of a vehicle accident, and that trumps this statute, and you have to prove permanent injury, which is not going to be pain or suffering if the expenses are $3,600 or more. I don't know what the New Jersey no-fault statute is, but nonetheless, I would have argued that. but I am shocked that this is going to the jury. I don't know if they'll appeal again. Maybe they didn't even raise it.
They can go up to the New Jersey Supreme Court, so that may be happening. That may be the next step.
This shouldn't be a judge who makes or it shouldn't be a jury who makes a determination about jurisdictional issues, which means, does the court even have jurisdiction to hear about this? And the Tort Claims Act, like, I don't practice a lot in New Jersey, but the Tort Claims Act should have said you don't get to step 2 unless you prove you have the serious injury at step 1. So great. Like I said, I find this very interesting from a procedural standpoint. I don't know whether anyone else will, but
I thought it was interesting from the operational standpoint, but you're absolutely right for the fire lawyers anyway out there. So.
Exactly. And I'm not sure, frankly, on the operational side, other than the old fire engines, I'm not sure if this could even happen again. With the new master controls and everything, could you put it into pump gear and cause it to drive away from the panel? I don't think, I've never done that, fortunately. But I'm not sure I could do that. I don't know that these master throttle controls allow that anymore. I don't know.
Yeah, I don't know.
Okay, this next one is horrible, if true. If true, right? And we start with everything. These are allegations and claims, which, if true, right? But we don't know the truth, as Curt and I, right? We always say, we don't know. We're not blaming anybody. We're not taking sides. We're just responding to the allegations. So now we're in Charleston, and we have a firefighter who has put forth claims that he's the victim of hazing, and that one of the hazing incidents caused an explosion under his bed when he flipped his mattress that led to loss of hearing. And look, there's a lot in this, right, to unpack, but he has a lot of allegations of a lot of individual instances of hazing where he believes he was singled out and hazed, right? Where he's cleaning the bathroom. He alleges he's the only person cleaning the bathroom, and that once he's done, people go in and mess it up, right, with their bodily functions.
That's a polite way of saying it.
Well, we're on YouTube now. I got to be really, careful. But he said he was told he's never going to fit in. Allegedly, he said he's put in transfers, but things are denied. He said he was forced to drill for extensive periods of time in the heat and everything, and that others weren't. So he's claiming that he is singled out, unlike other people. Now, the interesting thing is, he doesn't necessarily need to do any of that, in my impression. Whether he was treated like a whole bunch of other people or not, it doesn't matter. If somebody, take all the history out, if it's true that somebody put a incendiary device below his mattress and that it blew up and I don't think the hazing matters. I think we have some different issues, criminal possibly issues, etc. if it's true. And again, we're not saying it's not true. We're not saying it isn't true. But one of the things he says in here is, well, somebody thought he tried to commit suicide because they thought it was his gun. He was killing himself. And they throw that claim in there to say, see, everybody knew I was undergoing this intense harassment. And again, we're not saying he was or wasn't. But here, I don't think you need anything more. If there either was an explosive device or there wasn't, and if there was, it seems to me it's criminal. I think he wants the money of the fire department, though, right? So he's got to get the fire department brought in on the harassment and bullying, and you knew about this charge, so he needs to pull them in to get their money because they presumably have bigger money than whoever planted the device, if anyone's going to come forward.
Yeah, I think that's exactly it. And also, it's over the top allegations. I didn't include everything in the write-up. Is some disgusting things happen in the station, if they're true, if they're true. But certainly troubling allegations that we've got there. And, so they want to create this big problem area and then add that onto the incident where he lost his hearing and was basically forced out of the department. So we'll see what happens here.
And look, you and I have taken a, long stance on hazing, pranks, bullying in the firehouse. It's got to end, right? That's got to end. Now, we're not saying it happened here. We're just, right? We're not making allegations here, but it does have to end. And you could see how this could happen in a firehouse, right? His allegations are not, oh, not in the fire service, right? I mean, they're very believable allegations if, you know, in the fire service generally.
Some of them are hard for me to believe are happening, but if they are, you know, we've got people that should not be in the fire service if they're true. Right. One of the things that I know, I wrote this in an article for Lexapol. I'm not sure if it came out yet or not, but yeah, it did come out. It's on bullying. Is that a lot of times with bullying, we tend to look at it as a sort of a one-dimensional, somebody's being picked on, whereas some of the bullying, and I think that's only half the story, there is bullying that is really a function of the fact that people are not being singled out, and
indoctrination,
but they perceive themselves as being bullied. You know, certainly to differentiate this particular person, if the allegations are true, it would seem that he's being bullied, you know. Right. But if the allegations are not true, I mean, he had only been there, I think it was maybe a year. So he didn't last very long in the department. It wasn't like he had been putting up with this for 5, 6, 10 years. I believe it was a little over a year, or maybe even less. So, you know, which of the two is it? Somebody who's legitimately being bullied? Is it somebody who's perceiving themselves as being bullied, and then, you know, now wants to get back at people that they perceive were the bullies, and now is going to use the legal system to go back against them? Who knows? Who knows? Right. Maybe, probably like most things, it's probably somewhere in the middle, but it certainly is hard to tell what's going on.
Right.
So.
Okay, last one I think is on you.
Yeah. All right. Well, let's go to Philadelphia. Oh my God. And we've got it's kind of a confusing series of allegations, but essentially we've got two firefighters, one who's a captain with 38 years, another who's a firefighter with 25 years, both of whom had put into the city's DROP program. That's a deferred retirement option plan. And so that's sort of problem number one. They've locked themselves into retiring at the end of the DROP program. And there's certain financial incentives for doing it. I'm not familiar with all of the incentives, but I know often you basically declare that you're going to retire in a couple of years, and then there's some offsets that go in, and you lock in your pension at a certain rate, but then you collect additional funds when you do retire. So there's a couple of different ways I've seen them set up. Bottom line is they sign up for the DROP program. And at the same time, the union had historically advised members not to sell back their unused vacation time. In other words, take your vacation time. Don't sell back your unused vacation time. And something that I know unions will often say is that if you don't use your benefits, the city is going to turn around and use that in arbitration or negotiations to say you really didn't need it. Because if you really needed that 6th week vacation or 7th week vacation, then you wouldn't be buying it back. So therefore, you really don't need it. So I get that part of it from the union. But what the allegations are is that while the union was saying don't sell your vacations back, their executive board, I guess, or other elected officials in the union were actually doing that. And by doing so, they were able to inflate their pension. So they were actually taking advantage of it. And the allegation here then is that these guys, unfortunately, had put in for the DROP program, so they no longer were in a position to be able to increase their pension. And by selling back their vacation time, they subsequently found out that the union officials had been doing this and really didn't want a lot of people doing it for fear that the city would come in and get rid of it. And so they're alleging that the union breached their duty of fair representation by both affirmatively advising them not to sell back their vacation, while at the same time taking advantage of this program themselves, and Whoa, Brad just logged off. And eliminating, oh, he's coming back.
Hey, I just for some reason signed out. I
Yeah.
have no idea why.
Wow, that was a quick return.
Yeah, thank you. Thank you. No, I was gone for a while, and I was commenting. Not sure if I'm live. I love technology, live shows. I love them even more.
Yeah, no, it wasn't for very long. It was maybe 10 seconds, 15 seconds. So it wasn't very long. But at any rate, the allegation is that the union breached their duty of fair representation. Brad, I don't know how much you're up on collective bargaining law. My question is, I don't see how the city got named here. The complaint has one count of breach of the duty of fair representation. They didn't allege conspiracy. They didn't
That's what I was looking for. I was looking for a collusion.
Right. They didn't allege that the city, like you need a second count to allege that the city breached its agreement, maybe, or didn't inform the members of this. I'm not sure, but the city is named, so I don't know how the city stays in, but I think they need the city in there because they want to order the city to basically give them the same pension as if they had sold back their vacation time. So I don't know, any thoughts on that?
Yeah, I'm a little circumspect about the whole thing, and I'll tell you why. Not that we're not commenting specifically on the people's veracity, but if a union gives you advice, you are free to accept or reject it. The choice you make as a person may be based on other people's opinions, which, hey, they made a different choice, right? I'm advising that you may not want to give back your vacation time. We want to. And to say it's personally serving, well, personally serves me, personally benefits me, that's why I give you bad advice. I don't know, maybe it benefits the union, as you were saying, but ultimately they didn't deny them the ability to claim it. They just gave them advice, whether it was skewed advice or not. I don't know that that's enough to tell somebody that I'm liable for all your bad choices, right? It's not really fraud. And maybe let's assume it, even if it's misleading, you're still able to make your own choices. So I don't know that I would find in favor of the complainants here. I'm not saying that the unions didn't have unclean hands. We don't know what, right? At this point, we don't know, but I'm really circumspect to say that just because you gave advice to your members, it'd be one thing issuing a policy. Hey, we're all collectively doing the following, right? Yeah. We're not going to do this. This is our stance. We're not going to do it. Don't do it. But even so, they can't stop you from using your vacation time or not. Or I just don't think they're going to meet any burden here to prove fraud, collusion, unclean hands, whatever. I think it's a very tough road to hoe. And my biggest question was, how much is the money? It can't be that huge.
You wouldn't think so. I don't know if they're selling back 6, 7, 8 weeks of vacation time, but week of vacation time, it really, it should be 1/52nd, right? So you're whatever that comes out to.
And over a 25, 30-year pension that caps you at 2/3 or whatever. You're right. I don't know what the pension is, but I just have a hard time believing, why is this happening? I wonder if this is more the lawyer pushing it than the individuals. And unless they think they're going to get a class out of this, which they may.
They are seeking a class action status.
Okay, so there you go. I'm betting it's the lawyers who are saying, listen, you individually, you guys are getting like nothing. You're going to get like $50, but we're going to make a lot of money over the big area. It's a big department, right?
Philadelphia, absolutely. Yeah.
So, the class, they only have to prove one and that everyone else is similarly situated. So the class could be big. I bet this is what I call a lawyer-driven lawsuit, whereas the individuals aren't going to get anything. They don't care. They're happy to be figureheads because they're upset, right? But it's more about solving the wrong through a class action than getting 1 or 2 people money.
Yeah, and it's interesting because they filed in state court. So maybe, I'm not familiar with Pennsylvania law, if they have a class action statute that awards attorney's fees. But I know when you go into federal court, typically under those laws, you are going to get attorney's fees. So I'm not sure. Maybe there is under state law in Pennsylvania.
I'm sure, and it's probably capped in some way. But it's the only thing that makes sense to me, because this isn't a lot of money for any one person. So, and this is what generally upheaves unions, right? When you get a class of, a significant percentage of people. Now, the problem is, I wonder how many, because how many people retired here? How many people already made the choice under the statement, right? So there's got to be a statement and the effect. And how many people followed the statement that the effect, right, in that time was, oh, I lost certain amounts of money. That, I don't know, but, we'll see, I guess. So lawyers obviously must think they can make some money, because I just don't see any individual making enough that it's even worth it.
Yeah, I mean, bringing a suit like this is going to be big bucks. So either the law firm is bankrolling it, unless those folks are independently wealthy, and the end return is probably not going to be enough to justify the legal fees to bring this. So the law firm must be looking for that class action.
Yep. And the more interesting thing, which is true with all union votes, is don't forget, they've got to vote to defend this. So how big's their class? And does the class say, we don't want the union to defend itself? And then do they go after the individuals who made the statement individually? But then if they do it individually, they weren't acting on behalf of the union. I mean, there's all sorts of interesting procedural questions coming down the pike, which we won't, waste too much time on. But it's interesting. It's definitely an interesting issue.
Interesting, yeah. So, all right. Well, that's going to wrap us up for another week. Been an interesting week. I already have seen a couple of interesting cases break for this week, for this coming week. So I'm sure next week's going to be a good one. I am traveling to Washington State next week, so we won't be able to do it at 1:00. But hopefully we'll be able to probably do our class over the weekend before, and so it won't be live at 1:00, but we'll get it out there. But it'll probably be Saturday or Sunday. Okay. All right.